right, everyone, let's go ahead and get started. Welcome to today's webinar. It's going to deal with officer-involved shootings and critical incidents. For today, the panelists are going to be myself, Daryl Basco. I'm president of the Louisiana Fraternal Order of Police. Jim Gallagher, who is our treasurer and also our legal plan chairman from Crescent City Lodge number 2. Donovan Livicary, who is our state general counsel and is also an ex-policeman in New Orleans and a member of Crescent City Lodge number 2. Our second vice president, James Folks, was supposed to be on the webinar today, but he had an unforeseen issue come up, so I will do his part of the presentation. There is a chat feature available to the attendees that you will be able to use to either ask questions, communicate with each other, and also there is a Q&A portion that is available for you to ask questions. You can either, if you have a question as we go, you can either post it into the question and answer, and we will answer the questions from it, or either raise your hand and we will get your questions answered. We may not stop the webinar to answer your question immediately, but feel certain that before the end of this session, we will make sure to answer anyone's questions as we go through. So whenever we go around and have some talks with local lodges, this is one of the things that always comes up is, you know, if we have the critical incident in my local lodge, exactly what do we do, or what's expected for the FOP to take place. So in a basic scenario, it's 2 a.m. in the morning and a lodge member calls from you, and or you get a call from your lodge member since you're a local lodge leader, and they tell you, look, we've just had an incident. 2 officers have been involved. We've got 3 officers that are witnesses. We've got 1 subject on the run and 1 subject has been shot. So what is your response? Has your local lodge leadership gotten together, and do you have a response for what do we do? If you don't, this is some of the things that we're going to give you some items to consider. If you do, hopefully you have a good plan in place, and maybe you might hear some things today that gives you a little bit of added information or an idea that, hey, we don't do that. Maybe this is something we need to consider. So like I said, initial response, some things that you need to do as a local lodge leader is 1, immediately call an FOP attorney. We have about 25 to 30 of them that are part of the FOP legal plan across the state of Louisiana. You can go to foplegal.com and see the list of complete attorneys. And we ask that, you know, do that, have that plan in place. Reach out to a local attorney, such as somebody like Donovan, which he's going to be available, you know, 24 hours a day, 7 days a week for anything. But it's hard for him to get from New Orleans sometimes, depending upon what part of the state. So you may want to reach out and contact a local attorney that's an FOP attorney and speak to them and say, look, can we get a 24-hour cell phone number for you? Or do you have a group of attorneys that are FOP attorneys that we can call in at a moment's notice? Second thing, check on your officers. Gather details that are available for you to pass on to that local attorney whenever you do make the phone call. And some of the things you want to know, you know, is anyone in custody, and be able to arrange for that attorney member conference as soon as possible. The most important thing on the don't side is don't let other officers, the public or the media, speak to the officers involved. And I think Donovan will get a little bit more into this when he talks about the incident itself. You've got to remember, whether you're an officer that is involved, or you're a witness officer, or if you're a local lodge leader that wasn't present for the incident, and you show up and speak to that officer about the ins and outs and the comments that were made or what did and did not happen, well, then you become a witness to the incident. So the best thing is not, don't ask those questions. And like I said, Donovan will cover that a little bit more as we go. From the local lodge, sometimes the city isn't making any type of statements. You want to make sure that the public safety statement to the agency from your officer that's there, it needs to be limited to a short, concise statement about potential suspects, victims, weapons, and then vital information that's there about evidence, perpetrators, and witnesses. So, you need to make sure that your agency has enough information to be able to continue the investigation, but make sure that they speak to that attorney before you get there. So then, like I said, Donovan will get more into that information as we go. So before Donovan moves forward, we're going to do just a short poll here real quick. And we're going to launch it. And the question is, if there's a critical incident today in your agency as a local lodge leader, do you know what the response would be, or what response would you have? So just take a minute and be able to answer that question, and we'll see what the results are. Just a few more minutes, or a few more seconds rather, not a few more minutes. So overwhelmingly, lodges, 100% of the participants today, their local lodge does not have a plan as far as what they're going to do if a critical incident. So hopefully this helps as we go through the investigation and through the presentation. It helps you get an idea of what you need to do for the future. So now we'll go ahead and let Donovan start his part of the presentation with the investigation and exactly what to expect from FOP attorneys.
Thank you, Darryl. And just to jump on what Darryl was talking about, generally having a plan, it's important for local lodges to have connections with attorneys that are nearby who are willing to respond in the middle of the night to officer-involved shootings or other critical incidences. I don't mind if you call me, but the chances of me being able to get out to Bossier City are pretty slim. At least the chances of me being able to get out there in a timely fashion are pretty slim. So it's important to develop these relationships with attorneys in the local area and make sure that you have people who are willing to get up in the middle of the night, to answer the phone in the middle of the night, and potentially get up and get dressed in the middle of the night and go out to a hot scene to help out your the members of your lodge. You may have attorneys who are former police officers, like I was. I think those people are at least have a better idea of what you're asking of them, and hopefully you'll be able to at least identify some pro-police attorneys that are close enough to be able to get you a timely response. Anyway, I think that the thing that you want to be able to expect from attorneys specifically is that they're going to answer the phone. They're going to answer the phone, and that they are at least familiar with criminal investigations and in general. If they're familiar with your agency in particular, that's always helpful. If they have connections with the people who are going to be investigating these incidents, that's also helpful. So it's essentially, though, you need somebody who's going to be able to pick up the phone and at very least, give advice to the officers that are involved. Another thing that you need to do immediately is determine how many attorneys you need to contact. You may be able to get away with just calling the one guy that you know is going to respond and respond quickly, and they may be able to address everything. In circumstances where you have, for example, an officer-involved shooting, when there's only one officer involved, well, then there's no reason to have multiple attorneys. If you have more than one officer involved and it's questionable as to whether, or if there's any question, I guess, whatsoever, about whether these two officers are potentially at odds with one another, then they absolutely need separate attorneys. Witnesses, are, a little bit different, I guess, but you still have to be very careful with making sure that you have suitable representation for everybody involved. And the FOP's legal plan, fortunately, allows for you to have more than one attorney responding to an officer-involved shooting or a critical incident, and you can really provide solid representation for your members. It may require some legwork at the beginning to make sure that you have, the right connections and the right people on speed dial. In any event, one thing that we have to remember about critical incidents generally, and certainly officer-involved shootings, is that these are always criminal investigations. There is always some kind of criminal investigation involved with these types of incidents. They may be very quick. Your agency may begin it and end it just as quickly as end it as quickly as they began it. However, you do have to just be aware that there's usually some type of criminal investigation involved. And most recently, we saw legislation that was passed that's going to require investigators, like, for example, of officer-involved shootings, that are going to have to be seen a trend where departments are outsourcing these investigations to the state police. I think that we'll probably see that continue to some extent. And like I said, the new legislation requires specially trained investigators to investigate these officer-involved shootings or critical incidents. And so I guess what the agencies that are able to have those types of resources available here in New Orleans. In any event, point is that there is certainly going to be a criminal investigation, and the officers involved, and as well as the witnesses, really need to know and understand what's going on so that they can protect their rights. And that's what's really the most important thing here, is protecting the rights of the officers that are involved, because it's pretty easy for somebody with all kinds of bars and stripes and stars, or whatever the case may be, to come up on a scene and start all of that potentially jeopardizes the culpability, or the I don't want to use the word culpability, the potential for problems as far as the criminal investigation is concerned. In any event, let's move on. So we have this the critical incidents, this officer-involved shooting, we need to make sure that everybody knows, everybody involved understands their rights. And then we're not just talking about the police officer Bill of Rights, but also Miranda rights, right? I mean, these officers need to understand that they are the subjects of a criminal investigation at this point, and that they have the right to remain silent. They need to exercise that right. They need to make sure they exercise their right to remain silent until they're able to consult with somebody who is in a position to be able to have an objective view of what's going on. I can tell you that my experience with police officers is that they want to talk to people about what happened. They want to explain why they did what they did. And it's not always in their best interest to do so. I think police officers spend explaining what they did and why they did it. So, having to explain on an officer-involved shooting scene, it seems like just another step in the the day of a law enforcement officer. But obviously, it can have tremendous impact. So we need to refrain from doing that. So you would need the attorney that responds has got to be able to understand and advise the officer of their rights under the circumstances. They need to be able to advise the officers on what is coming, what they should do, and generally, why, a little explanation of why. A lot of what goes on as a response to these situations, officer-involved shootings or critical incidents, is a lot of it's beyond the officer's control. And to some extent, whoever's responding, the attorneys responding to help these officers are, they're going to function to make, just if nothing else, to make the officer feel better about what's going on around them, so that they don't feel alone. It's very easy under those circumstances to all of a sudden feel like it's you and the rest of the world. So it's really of vital importance for the officer that's involved to at least have somebody that they can talk to, right? Because nowadays there's a lot of focus on isolating the involved officers from other responding officers, so that their recollection of events and so forth doesn't get contaminated. And so anyway, it's important for officers not to feel a huge investigation all by themselves. As the slide says, it's important for the attorney to be able to give the officer an idea of what the process is going to be, and not just for the time immediately following the incident, but for several days after that. For example, most agencies, the vast majority of agencies, won't take a statement from an officer immediately. They'll wait 48 to 72 hours before taking a statement from an officer. Why do they do that? Because there are scientific studies that have shown that the officer's recollection of details increases after a couple of full nights of sleep. For that same reason, you don't want officers going out and drinking after an officer-involved shooting or a critical incident. And for other reasons, we don't want to do that. But it also impacts alcohol. The intake of alcohol impacts somebody's ability to recollect details. So we want to treat these officers need to treat their bodies in such a way as to make it more likely to be able to recall these details, and when the time comes that they need to recall these details. The other thing about obviously about going out drinking in a bar room is that you don't want people just going and losing, making bad judgment calls and spouting off to the wrong person, or maybe getting into fights, that sort of thing. I mean, I've unfortunately seen that people respond to, this type of pressure in different ways, and alcohol just simply does not help people formulate good judgment. I mean, I don't know how else to put it. It's just a bad idea. Another thing that they need to be able to explain to these officers involved is who it is they can talk to, because you need to encourage these folks that are involved in these incidents to talk to people. They have to be able to talk to people. They can't keep things bottled up and not express the emotions that are involved. I mean, it's not every day that people are involved in these situations. People generally don't have to shoot other people. It's a circumstance where it weighs heavy on the conscience of people that are involved. And, if you've not having been involved in a situation like that, it's difficult to really appreciate what it feels like to have been involved in it. But it weighs heavy, and you need to be able, these people need to be able to talk to other people. Now, you may have peer counselors or an officer assistance program that's available, but a lot, and they need to understand who they can talk to, who they have privileged, who can they have privileged conversation with, who are the courts or the agencies not going to be able to order that person to tell what you said, what the officer said, right? So, for example, you enjoy a spousal privilege with your husband or wife. So you can't, the judge or court or whoever can't order your spouse to testify against you, or to reveal the what it was that the subject matter of your conversations. An attorney and a client, attorney-client privilege, right? You have a privilege that exists between people and their spiritual guides, right? They're priests or whatever kind of, it can't just be some random guy who happens to be a priest or a reverend or something. It has to be somebody that you actually have that type of spiritual guide relationship with. In any event, there are people that you can talk to. There are people that you need to refrain from talking to. So, for example, I would suggest that officers don't talk to their coworkers about what happened, at least not right away. Now, I'm not talking about peer counselors or that sort of thing, but in particular, I'm talking about their fellow platoon members or people that are on their shift. For the time being, they need to refrain from talking to those people, in particular about any details of the incident that occurred. I'm not saying you can't tell people hello or how's the family, but you want to refrain from discussing the details of the incident that the officer was involved in. You also need to stay off of social media. It's everywhere these days. It's hard to avoid. But the last thing you need to do is explain for the officer to explain why they took the action they took on Facebook or on Instagram with a picture of the EMS wagon, who knows what, but it's just a bad idea. So I would certainly suggest that the officer needs to be told not to do that. It's just as simple as that. All right, let's move on. So I could probably ramble for quite some time. I know I've already done that. So the responding attorney, like I said, each person hopefully will have one person that they can talk to that, like I said, it doesn't impact that person's ability to talk to another officer, right? So I mean, you need to be able to make sure that you have the appropriate allocation of representation. You need, just to get an idea of what happened, you need to be able to understand what happened and what happened in light of the public safety statement. I don't remember, I know Darryl mentioned the public safety statement earlier. The public safety statement is geared to be a way for the officer to be able to provide information to the agency without providing any real information that could be detrimental to the officer. What happened was they had officers who would be involved in an officer-involved shooting or a critical incident, and that would literally refuse to say another word until they were able to consult with their attorneys. And while in general, that's a good idea, in reality, it's not necessarily always practical, because if there's some nut job in the bushes 20 yards away with a automatic weapon, and the officer that's refusing to talk to anybody knows that that person is there when they open fire, it seems like that's something that could be prevented, right? So these are the kind of things that is supposed to be dealt with through the public safety statement. Are there risks to the officers that are responding to the scene? Are there risks to the public? Immediate risks to the public, additional perpetrators at large? Is there evidence that is going to be lost forever if the investigators aren't made aware of it? Those are the things that are addressed in the public safety statement. The public safety statement should not include why the officer did what they did, what they were thinking when they approached the house, what information they were given by the dispatcher, what, these details that are part of the overall incident are not what's at issue here in the public safety statement. It's going to be generalized things for, as the name implies, the safety of those around the public and responding officers. Anyway, let me see if I can get this moving again. You need to, the attorneys need to refresh the officer's memory if need be. Of course, any walkthroughs, you have to be careful of making sure that you don't step through a pile of casings. A lot of times officers have to make administrative statements regarding these incidents or use of force incidents. Here in New Orleans, for example, we have to, officers who are involved in any kind of use of force have to make a force statement. And a force statement is part of the administrative investigation. It's not shared with the criminal investigators. but it's going to be dealt with differently than you would deal with the criminal, a request for a statement by the criminal investigators. The point is that the attorney should be able to advise the officer involved accurately on how to address these. Here, details matter. All the details matter. This is, these circumstances can make the difference between somebody all of a sudden having their freedom taken from them. So it's very important to make sure that all really, like it says, the goal is always to get a full and accurate statement from the officer. It's important to know all of the legal and policy issues that are involved, so that we can make sure that we have the appropriate coverage for the officers. Like it says at the end, everything's covered by the attorney-client privilege. So whatever is discussed between the officer involved and the attorney is privileged conversation. That now there's a little bit more to it. It's never quite as easy as it seems, right? So make sure if you have any questions about what's privileged and not, that you ask the attorney that's involved, and they should be able to explain it. For example, if you have if I'm representing Darryl and I have a conversation with him here in this virtual world, that's not privileged communication, right? Because there are other people that are involved, there are other people that are listening, so that takes it out of the realm of privileged communication. But anyway, the attorney should be able to explain that to the officers that are involved, so that they have a reasonable understanding of what that means. Anyway, let's move on. Criminal investigation. Like I said earlier, there's always criminal investigation. Let's go ahead next slide there, Darryl. Criminal statements are always voluntary, and that's true even for law enforcement officers, right? So the courts are good for sending mixed messages on things, but one thing that they have not done is taken away the Fifth Amendment right against self-incrimination for law enforcement officers. So the courts have actually held that that as far as this is concerned, officers are not entitled to some watered down set of rights. So any statements made in a criminal investigation are voluntary. These are written, oral, whatever, it's still voluntary. So the officer and the attorney may choose to make a written statement, to make an oral statement, or to exercise the right to remain silent. You always want the attorney present during any statements, or and for any written statements, they need to have final review before it's submitted. It's always best to have the attorneys deal with investigators and prosecutors. Sometimes these departments are not that great at communicating with attorneys, but hopefully, if they understand that the attorneys are there on behalf of not only this officer, but any other officer that would be in similar circumstances, I think that generally makes police officer investigators, I guess, a little bit more able to communicate with the attorneys that they may not otherwise be willing to be so accommodating with. All right. Grand juries are something that the officer would have to address specifically with their attorney, for specific circumstances. So it's certainly something that needs to be coordinated between attorney and client. All right, let's go to the next one. There's always an internal investigation as much as there's always a criminal investigation. Now, again, your agency may breeze through this so fast that you didn't even know one ever started. I've seen, agencies where the officer really had no idea that they ever conducted an administrative review. We're getting farther and farther away from those days nowadays, but it does still happen. But for the most part, there's an administrative investigation and the officers are involved or aware of the administrative investigation. The administrative investigations normally involve compelled statements. These are statements where the officer is ordered to participate in the question and answer or the interview, whatever, however you want to describe it. In the Police Officer Bill of Rights, they describe it as an interrogation. If you are, well, the Police Officer Bill of Rights says that any statements that are made in part of the administrative investigation are inadmissible in criminal proceedings against the member. So, the question of admissibility is a question for a judge, and a criminal proceeding is not the investigation, but criminal proceeding, trial proceedings, that sort of thing. But the officer involved is generally protected from making incriminating statements or self-incriminating statements. That doesn't mean that those statements can't be used against somebody else. So witness statements or accused officer statements in an investigation where they're ordered to make the statements is still able to be used against another accused officer or another officer. So it's not that the statements are sealed off and thrown into a locked file somewhere. They just can't be used as self-incriminating statements for the officer that made the statements. You also have to be under threat of termination in order to get these Garrity protections. That's commonly known as Garrity protections. You have forms, Garrity warnings and Garrity rights and stuff like that, but it all boils down to your Fifth Amendment right to remain silent and whether or not your agency has taken that right to remain silent away from you. So typically in administrative statements, that's the case. And then, like I said, the Police Officer Bill of Rights in particular says how that can't be admissible evidence against you. There will be, each agency is a little bit different, so it's good for if you have an attorney who's familiar with the process for your particular agency. That way they know about things like shooting review boards or use of force review boards. That it's important to at least have resources available to the attorneys representing your members in these circumstances so that they can get the answers to these questions, or to at least make sure that they're not missing something, that there's not something big around the corner that they're just unaware of. You'll want to make sure the attorney wants to make sure that they keep open lines of communication with the officer involved, so that they make sure that they don't miss any part of the disciplinary procedures, and that they're able to provide representation to the officer involved on all of these disciplinary procedures. You always have to act as if there's going to be civil litigation that follows. I mean, on some level, it doesn't change what police officers do, right? I mean, all you can do is go out there and do the right thing, and then and you do what you got to do, right? It doesn't hurt to be aware of the fact that there is more than likely going to be some, it'll be I'm sure there'll be some kind of communication with the city attorney's office or whoever represents your agencies but it's something that we need to, the officers involved need to maintain open lines of communication with their attorneys and the attorneys for their agencies to facilitate a defense to these civil actions. Now, we have to keep in mind, though, that all of this is secondary to making sure that officers' rights are protected in the criminal investigations, because if they're going to go inadvertently spend several years in jail, and then it's not, it makes the prospect of civil litigation seem less important. So it's something to be aware of, but immediately following an officer involved shooting or a critical incident, you need to keep your eye on the ball and make sure that those avenues are protected. And then you can move on to the civil stuff when the time is appropriate. All right, what's next? Darryl, you got that? All right. In Louisiana, disciplinary records are public records. The courts have held that, with the exception of things that are found in like RS 40, 2532, the officer's home address, social security numbers, those kind of things, those are not public record. They can be redacted from public documents, but for the most part, disciplinary records are public. Police incident reports, initial incident reports are always public record. Supplemental reports are not, if they are the the product of with potential criminal litigation. But this is something that's a lengthy discussion. It's just, I think it's safe to assume everything's public record. Like it says on this slide here, nothing is private. Don't use your department email address for anything except for department communications. Don't use your department phone for personal communications. You have no expectation of privacy when you're communicating in these ways, and there are just too many free options that are available to people these days to risk or to take on a risk like that. It's just, you can, instead of using your department phone to text people, you can get Signal for free, which allows you to send encrypted texts. You can use Proton email for free, that allows you to send encrypted emails or whatever, as long as it's not your department email where they have a master key and go snooping around because they feel like it. Things like that have a way of working against you, and people can interpret things the way they want to interpret them, and that's just never the best idea. Again, the attorneys should be able to have these discussions with your members and make sure that everything is covered. Is that it for me, or is there anything left for me, Darryl?
Sorry. For right now, that's the end of Donovan's part of the presentation. I feel sure Donovan's going to hang around, so that way, if anyone has a question as they're trying to process a lot of this information that we're given, they can post something in the Q&A to ask Donovan a question, and he'll be around to the end.